Welcome to Muska Law Radio, a program dedicated to criminal defense. Muska Law is a criminal defense firm with offices throughout Florida, including Broward and Palm Beach counties. Your host today is attorney Harley Brook, a full-time associate of Muska Law. Mr. Brook has been practicing criminal law for 12 years and has devoted his career to representing clients on criminal defense matters. Mr. Brook is a former statewide prosecutor and a former assistant state attorney. In addition, he served as a magistrate presiding over traffic. If you or someone you know is under investigation or accused of a crime, or if you have any questions related to criminal law, you don't want to miss today's show with attorney Harley Brook. To watch this show stream live, visit muskalaw.com. That's MUSCALAW.com. And click on the radio link. Now, here's attorney Harley Brook.
Good afternoon, folks. Harley Brook with Muska Law Radio here. Excited to be with you on this fine afternoon, 5 o'clock. We're excited about the new time slot, and we're excited about following you on your way home from work. Last time I was here, we started talking a little bit about DUI trials, when a DUI case actually goes to trial. And so I'm going to kind of continue in that vein. In the meantime, if you have any questions, if you want to call in with any questions relating to DUIs or DUI trials, please feel free to call at any time at 1-888-565-1470. That's 1-888-565-1470. All right, now, before we get into the nuts and bolts of a DUI trial, what has to be determined between the attorney and his client is whether or not to even go to trial. So there's going to be pretrial negotiations between the state attorney's office and the criminal defense attorney, and obviously the attorney will have to discuss with his or her client the strengths and weaknesses of their case, and what the plea offer is, and whether or not it would be worth the risk-reward ratio to go ahead and proceed to a trial, or whether the client's interests might be best served by negotiating the best possible deal. In my line of work, I found that normally I have three types of clients. The client that will engage us and right off the bat say, I didn't do it, this is a travesty of justice, you know, I'm not guilty of this, I'm not taking any kind of a deal. Well, that's great, and that's what the justice system is for, to protect folks that truly have not committed a crime or are innocent. And remember, in all cases, not only DUIs, but in all cases, the saying is, of course, you are innocent until proven guilty. And that's innocent until proven guilty beyond and to the exclusion of every reasonable doubt. So anyway, we have the client who's very adamant, didn't do it, not going to take a plea offer. You know, either you get the state to drop it or we're going to trial. You have the client then who's on the opposite end of the spectrum, that walks into my office and says, yeah, Harley, I made a mistake, you know, I was very inebriated. Just, you know, do everything you can to get me the best possible outcome to the case, keep me out of jail, do the best you can to make sure that you minimize the damage here for me. And then the third type of client is someone in between those two. Well, you know, I might have been a little impaired, but I don't really think I was DUI. See what you can do for me as far as plea negotiations. If you get something that's reasonable, that works out, I might be able to accept it. If not, we'll go to trial. So basically, those are the three major types of clients that I found that we deal with primarily. Of course, there are people that fall within those ranges, but those are the three main types. And so that plays a huge part, of course. The client's disposition coming into this matter plays a huge part into whether or not they ultimately go to trial, or if they want to resolve a case by way of a plea, the best possible plea offer. With DUI cases, normally if the defense attorney can obtain a reckless driving offer to make the DUI itself go away, Normally, that's a very good disposition. There are some cases where that might not be a good disposition. If say, for example, the client looks very good on the video, doing the field sobriety exercises, the one-legged stand, walk and turn, whatever field sobriety exercises may be administered at that particular time. Let's say the client looks very good, and then the client either refuses the blow or blows under the .08 or perhaps slightly above the .08. That might be a very triable case that the client would be best served, going to trial. But again, the client's disposition obviously plays a huge role in it. Some people are very scared to go to trial, have their quote-unquote dirty laundry aired out in front of a jury of their peers and whoever else may be watching, and want to resolve it as quietly as possible. Others, again, want their day in court. My job as an attorney and any competent, experienced DUI attorney is going to review the facts of the case in its totality. Are there good facts for my client? Are there bad facts? What is the plea offer that we've been able to obtain from the prosecutor? Can I improve upon it? Usually the first plea offer is not the last one. Normally I'm able to get an improvement of some kind with the plea offer. Sometimes it can be as drastic as a plea offer for a DUI with increased sanctions all the way down to a reckless. Sometimes it might be a less drastic change, such as reduced fines, reduced driver's license suspension, things of that nature. So again, my job as an attorney is to take a look at the facts and the likelihood of a conviction if the case goes to trial, or an acquittal, obviously, and weigh that against what the best possible plea deal was that we were able to negotiate on behalf of our client. And of course, it's a scale. The weaker the case for our client, the more inclined, obviously, you're going to be to take a plea deal. The stronger the case, the less inclined you're going to be to take a plea deal. And obviously, leverage plays a huge part in it as well. If the facts are strong for you, obviously you have more leverage with the state attorney's office, and we're able to negotiate very good deals. I had a particular client that coming in looked like a very difficult case. She actually blew well over the legal limit, well, even over 0.15. I think she blew over a 0.20. Was, in all honesty, very inebriated. But there were some legal issues that I was able to seize upon. Basically, the driving was involved prior to the officer arriving, and so that's not an issue for the state as long as they have what are called wheel witnesses. So if they have a wheel witness that can come into court and put the person behind the wheel just prior to the officer arriving, then they can salvage that. However, in this case, the wheel witnesses were my client's own family. And they, I had them prepare notarized statements under oath that contradicted a lot of what the law enforcement officer had stated in his probable cause affidavit. And frankly, I made it more than clear to the prosecutor that these were not going to be easy, willing witnesses if the case were to go all the way to trial. And so let's negotiate. And negotiate we did, and eventually I was able to get a reckless driving offer at the last minute. On a case where the client blew over a 0.20. So again, everything counts, and you got to look at every single aspect of the case to be able to use it in your client's advantage to obtain the best possible outcome. So other considerations to take when deciding to go to trial include who your judge is. What would that judge do if you were to be found guilty? of the DUI. Because obviously we can weigh the strengths and weaknesses of the case, but at least not yet. I don't have that crystal ball that's going to tell me with 100% certainty if that jury is going to come back with a guilty or a not guilty verdict. So what would a judge do if you were to be found guilty? And is that a risk that you are willing to take? Using examples from my past as a prosecutor, which was many moons ago, but still relevant today. There was one particular case that I took to trial as a prosecutor, and I obtained a conviction. First-time offense. Judge gave her 30 days in jail. Other judges would have not given her any jail whatsoever. So the moral of the story there is know thy judge. And it's very important to know what the consequences and ramifications of a possible guilty verdict would be, depending on who that judge is. So that's very important to know. Again, if you wish to call in with any questions, the phone number to call is 1-888-565-1470. That's 1-888-565-1470. Again, so know your judge. Know what it is that you're going up against. And that's why it's so important to have an attorney that's not only experienced and knowledgeable, but also has local knowledge, knows the judge, knows the prosecutors. So that's important as well, because all of that counts. Like I said before, a judge can, on the same exact case, same set of circumstances, one judge might give jail time on a guilty verdict, another judge may not. So that's important to know. Again, there are no guarantees in regards to what's going to happen as far as what the jury's verdict may be, but obviously with an experienced and competent attorney, they can give you a fair estimation of at least how likely a conviction might be as opposed to an acquittal. But what plays a huge role into that, obviously, is the process of jury selection. That's kind of what I talked about last time I was doing the show. And jury selection is a very, very important process within the DUI trial, with any trial for that matter, for two reasons primarily. One, of course, you want to make sure that you get the 6 people, and an alternate if need be, that are going to be most like-minded to you, who are going to be most favorable to you. So you want to exclude those people, for example, that have had family members that have been victims of a DUI accident, perhaps very religious people that are against drinking altogether, folks that you know just would not be good to sit on your jury panel. You get 3 peremptory strikes. That means you can strike 3 people for pretty much any reason, as long as it's race neutral and gender neutral. So 3 for any particular type of reason, and you get unlimited challenges for cause. What that means is basically if somebody says, Mr. Brook, I'm sorry, but I can't be fair and impartial here. I hate drunk drivers. I just can't do it. Well, the state's probably, during their jury selection, if that information comes out, they're going to try to rehabilitate him, but chances are the damage is done at that point. We could get him kicked out for cause on the basis that there's just no way that particular juror could be fair and impartial to both sides. So unlimited challenges for cause, 3 peremptory challenges. That's what we get. The jury pools obviously have a huge determination on what kind of a jury you're going to have sitting for your client. You may have a very friendly jury pool, you may have a not so friendly jury pool, and then it's a matter of selecting the 6 jurors that are going to be the least worse, if you will. Or sometimes the prosecutor is just going to be falling all over him or herself to try to get all those people that may be very friendly to our client. So again, and those are things we don't know ahead of time. We're not going to know, obviously, what kind of jury pool we're going to have. So it's going to be our job as DUI defense attorneys to not only exclude the bad jurors and the jurors that would be bad towards our side and keep the good ones, but almost as important is educating the jurors. That's the second component of jury selection that's so very important. It's important for folks to know even some basic things such as it's not against the law to drink and drive in this country. It's just not. If that were the case, we'd probably have significantly less bars, taverns, saloons, whatever. So it's certainly okay to go out and have a drink or two, or however many, before you are impaired. That's what makes it illegal, is obviously the impairment aspect of it. So, but it's important for the jury to know, hey, it's not a problem. It's not illegal to have a drink or have even a few drinks, depending on the person's weight and size and all that, and then drive. The only issue is whether or not that person was impaired. All right. So there may be a factual situation where it's not in dispute that the client did have some alcohol, did have something to drink. That's not something that we're going to be able to, not have the jury know. So in that particular circumstance, as in general, it's very important for the jury to know that there's nothing wrong whatsoever with somebody going out, having some alcohol, and then driving, as long as they're not impaired. So it's important to educate the jury as much as to pick it. So those are the two main components of jury selection. I would argue equally as important. Cases can be literally won or lost in jury selection. If you leave on your jury panel even one person, now sometimes you don't have the option because you've run through your peremptories and you can't get that person out for cause, but that's why you have to be very strategic in the jury selection. You may want to keep somebody that's not so great on that jury panel in order to not get into somebody that might be even worse later on. So strategy is very much involved here. And I discuss this with my client when it comes time to picking a jury. I'll get their input. They might see something that perhaps I didn't see, as far as a glare from one of the jurors or something that just didn't sit right with them. So we definitely get our clients involved. We give them a pad and paper and let them help with the process as well. We're going to take a quick break here, and when we return, we'll go ahead and talk about the process after jury selection.
Times are tough, and right now those in the commercial world know that being heard via advertisements is the name of the game. AmpSquare.tv understands how important advertisement is and is proud to express that it's truly the only plugged-in internet television production company on the market. Amp2.tv live streams all their shows across all the major selling markets in the U.S. and abroad. Call them at 866-224-5422. The AmpSquare.tv library allows productions to be seen over and over again, making commercial platforms more usable. Call 866-224-5422. Toll free 866-224-5422. Amp2.tv, the first and only internet television network that's truly plugged in. 866-224-5422. That's AMP2.TV. You are listening to Muska Law Radio with offices throughout Florida, including Broward and Palm Beach counties. If you have questions about criminal law or related matters, call into the show at 1-888-565-1470. Join us every Monday at 5 p.m. for Muska Law Radio, a program dedicated to all criminal defense matters. Joining us live now in our studio, here is attorney Harley Brook.
Okay, so we were talking about jury selection, and one of the other processes that happens, usually even before jury selection actually, is the attorney will file what are called motions in limine. Those are basically motions that seek to usually exclude evidence, or sometimes, put something before the judge that may be arguable either way, but that the attorney wants to know ahead of time if it's going to be admissible. But usually the motion in limine would be something meant to exclude any particular type of evidence from the trial and from the jury. So if there's, let's say for example, I'll just give you an example. Let's say during the video on the way back or on the way to jail, video is taping the client and he's talking with the officer, and he mentions, yeah man, I got one of these 4 years ago, I'm in big trouble now, that's bad. That's a motion in limine right there, because a jury cannot know or should not know that the client has priors. All right, so prior bad acts as well as prior convictions for DUI are inadmissible. And so an attorney, a good defense attorney, should be very keen and aware of any potential evidence that should be taken away from the jury or not shown to the jury, and that would be in the form of a motion in limine. There are also motions to suppress, which we've talked about in prior shows. I'm not going to go too far into that, because usually motions to suppress are heard at a separate hearing time, usually well before the trial, sometimes even weeks or months before the trial. Certain judges will hear a motion to suppress, the day of the trial. And a motion to suppress, of course, is motions such as a motion to suppress a stop by saying that the officer didn't have probable cause to stop the person in the first place. It could be a motion to suppress the breath test result because, for example, there wasn't a proper 20-minute observation of the suspect prior to him or her blowing into the machine. Whatever evidence we're seeking to have suppressed. Again, it's usually unusual to have something like that, which could literally sometimes, if it's, for example, motion to suppress, it's unusual to have that heard the day of the trial, because that would mean that the whole trial would go away potentially if the judge found that in fact there was no probable cause for the stop. But on some occasions, on perhaps lesser issues, that would simply exclude some of the evidence as opposed to all of it, those may be heard on the date of trial. So motions in limine and motions to suppress would be something else that would happen right at the beginning of trial, and usually before jury selection. So jury selection. So you got a jury, you got the best you could. You might be ecstatic, really happy you got a great one, or you might be like, well, this is the best we could do. And then, so what happens next? Opening statements. The state attorney's office, the prosecutor, is going to have the opportunity to lay down for the jury what they believe the evidence will show. This is not a time for argument. It's an opening statement. It's not an opening argument. Okay? So both the prosecutor as well as defense attorney are kept to only evidence that they believe will come in, and not arguments in regards to that evidence. So, the state might say, the evidence will show that on June 24th, 2013, Michael Anderson was pulled over, and, officer smelled a strong odor of an alcoholic beverage, this, that, and the other, and then just lay out the facts. The prosecutor, on the other hand, cannot say, for example, Mr. Anderson was stinking drunk. Arguments simply are not the time. That's not the time to make arguments during opening statements. That's the time to lay the groundwork for the facts that the prosecutor and defense attorney anticipate in good faith will be shown. However, it does set the tone for the trial, so obviously those facts are going to be laid out in a manner most favorable to their side. So the prosecutor obviously is going to highlight the facts that are favorable towards their case. I'm obviously going to highlight the facts that are favorable towards my client. So, for example, I might say the evidence will show, and you will see on the video, that my client does not stumble while doing the walk and turn. He keeps his hands at his side. He performs his field sobriety exercises as instructed. The evidence will show that my client blew 0.07 if a case like that does go to trial, and we love those when they do, and things of that nature. So basically, it's a factual thing, not an argumentative thing at that point. The defense always goes second. Just as the case is in chief, the state attorney's office goes first. Once they're done, they rest, and then the defense attorney will have an opportunity to present their own witnesses if they have any. And we'll talk about the question of whether or not to testify in just a little bit. So after, and another thing is, the defense attorney can have the option of having his or her opening statement immediately after the state attorney's office or the prosecutor gives their opening statement, or they could actually defer until the beginning of their case in chief. In other words, the defense can sit back and defer, let the state put forward all their evidence, and then give an opening statement prior to opening their case in chief. That's a strategic decision. I normally don't like to do that. There are circumstances where it might be a good idea, depending on bits of evidence that may or may not come into play, and I want to take a look at that and know that before giving my opening statement. For the most part, I like the chance to be heard immediately after the prosecutor, so that we can immediately rebut those factual allegations that they make with factual allegations of our own. But again, that's fact specific. There may be circumstances where deferring might be a good idea. It would then be up to the state to call up witnesses. Usually, in DUI cases, they're going to be law enforcement. Sometimes, as I discussed before, there might be a wheel witness, a civilian witness, that puts the defendant behind the wheel of the vehicle. They may call somebody like that. But for the most part, it's going to be law enforcement. And it's obviously the defense attorney's job to not only cross-examine them vigorously, but to make sure that there is no inadmissible or improper evidence that comes out during their direct testimony. If you have any questions, please give us a call at 1-888-565-1470. That's 1-888-565-1470. So talking about witnesses, and I've had cases where the officer will, sometimes inadvertently, mention a prior bad act. And what I mean by a prior bad act is some type of act. Doesn't necessarily have to be a conviction for any type of criminal offense, but some type of prior bad incident or act that would tend to weigh heavily or weigh at all against the defendant. I'll give you an example. Obviously nothing as outrageous as this usually happens, and I certainly hope it wouldn't, but for example, if the officer says, "Yeah, I know Joe Smith. He's the town drunk. I see him walking out of bars every night, stumbling around." Well, those are a series of prior bad acts, and certainly inadmissible. The jury's not supposed to convict or acquit somebody based on what they've done in the past, or their character, or things of that nature. They're supposed to either convict or acquit based on the facts and circumstances of that particular case. That is why prior convictions as well are not admissible. There's exceptions for that, but we'll get into that when we talk about the decision to whether or not testify if you're a defendant. So again, defense attorney's job, make sure that none of that evidence that is inadmissible comes into evidence. So the moment that I hear a prosecutor ask a question that I know is going to be improper, I stand up and I object on whatever basis. Could be hearsay, could be argumentative, well, not argumentative on direct, but you know, it could be a number of different things, speculation, hearsay, a number of different objections that I could pose. And the judge, of course, will listen to the objection, decide whether it's proper or not, and either sustain the objection or overrule it and allow the witness to answer. And then once the prosecutor has gone through their direct examination of that witness, obviously it'd be my turn to cross-examine them. And that's where thorough trial preparation really comes into play. I've won cases before. I would say 80% of it on pre-trial preparation and 20% of in-trial strategy. One particular case that I had, and it wasn't a DUI, but it was an extremely serious case. It was actually a capital sexual battery. When I got the arrest report for my client and I looked at the facts, I just looked at it and said, wow, this guy's in trouble. These are bad facts. But through a series of depositions, I was able to gather evidence like dominoes, one after the other, that made for a strong case. And I was able to actually have my client acquitted of a crime that could have sent him to prison for his entire life, based on thorough pretrial preparation, specifically depositions. Now, depositions are something that in most DUI cases are not allowed, but there's a frequent exception. If you contact us or you know, any good criminal defense, DUI defense firm, within 10 days of being arrested, you can have a formal administrative hearing, which is basically an appeal of your driver's license suspension. So at that time, we would subpoena officers to come before the DMV. We would question them. Those statements would be under oath and would be a good form of cross-examination right before the trial. Normally depositions are not allowed in misdemeanor cases, so that's a good way to actually get a deposition in a misdemeanor case. Most DUIs are misdemeanors unless they're you know, a third within 10 or a 4 or more. So we wouldn't have the opportunity to take depositions unless we filed a motion for the judge, and we'd have to explain, Judge, you know, this is why we need a deposition. His probable cause affidavit is insufficient. There's missing information, and you know, he can't come up with it, or whatever the case may be. Only in those situations would a deposition be granted in a misdemeanor case. However, like I said, with the DUIs, those formal administrative hearings actually serve like depositions because they're essentially the same thing. You have the witness, law enforcement officer under oath, you ask them questions, and those questions, or the answers to those questions can be used against the law enforcement officer in a subsequent trial. So another important thing for a good defense attorney to do is to try to determine, is there something missing that we do not have within the discovery, which is all the evidence that the state gives us, that we need to take a deposition for. It could be of a law enforcement officer, it could be of a civilian witness who did not give a statement. So that's something definitely to look at in order to make sure that pre-trial the preparation is not only adequate but phenomenal to get that good outcome at the end of the day. All right. So again, first the state has their case in chief. They'll call their witnesses, law enforcement, civilians, whoever. We'll cross-examine them, and at the end of that, it'll be our turn, and we have our own case in chief. Now, in many circumstances, we may not have a single witness, and we would simply attack the state's case by cross-examining their witnesses and attacking their evidence, showing how weak it is, and certainly not to the level of proof beyond a reasonable doubt. we may or may not have a witness. If there was a passenger in the car that was with our client the whole evening and can testify that he had 2 beers over a period of 4 or 5 hours and was driving fine, he's known him forever, and he knows that he was completely sober, that might be somebody we call. If the client was by himself in the car, then we need to determine whether or not it's in the client's best interest to testify or to not testify. Going back briefly to jury selection, one of the things that we must let a jury know is that the defendant is under no obligation to testify. And if the defendant does not testify, that cannot be used against him. The defendant, throughout the entire stage of the criminal justice procedure, from arrest through the end of a trial, has the right to remain silent. It's a Fifth Amendment right that's guaranteed to everyone. And if the defendant does not testify, that cannot be used against him. We want to make that very, very clear in jury selection. So, to testify or not to testify. Obviously, we as attorneys, as officers of the court, cannot put perjured testimony in front of the court. So if we know our client had 7 beers and 3 shots and was 2 sheets to the wind, I can't put that client on the stand, period. So if the evidence from the state in and of itself is insufficient, in my view, to sustain a conviction beyond and to the exclusion of every reasonable doubt, we're going to make them do their job, and we're going to attack their weaknesses, but we're not going to put our client on the stand, because he or she will not have good information to offer for himself. We're going to keep him off the stand. All right. Other considerations. I talked about the fact that prior convictions cannot be used against you, and that is true with the following exceptions: felonies and crimes of dishonesty. Those are admissible if and only if the defendant takes the stand. So let's say that I have a client that's been convicted of 5 felonies. Right off the bat, that's something that we really need to consider before we ever think of putting him on the stand, because that jury panel is going to know that my client was convicted of 5 different felonies. They're going to think this guy's a criminal. And even some misdemeanors can be put into play as crimes of dishonesty. For example, a petty theft or giving a false report to a law enforcement officer can be considered crimes of dishonesty with which our client can be impeached. So if there are prior convictions that fall in either one of those 2 categories, crimes of dishonesty or felonies, then certainly that's a huge situation to consider in whether or not to have the client testify. So we're going to take a short break, and after that we'll continue discussing the progress of the trial through the defense's case in chief.
Times are tough, and right now those in the commercial world know that being heard via advertisements is the name of the game. AmpSquare.tv understands how important advertisement is and is proud to express that it's truly the only plugged-in internet television production company on the market. Amp2.tv live streams all their shows across all the major selling markets in the U.S. and abroad. Call them at 866-224-5422. The AmpSquare.tv library allows productions to be seen over and over again, making commercial platforms more usable. Call 866-224-5422. Toll free 866-224-5422. Amp2.tv, the first and only internet television network that's truly plugged in. 866-224-5422. That's AMP2.TV. You are listening to Musca Law Radio with offices throughout Florida, including Broward and Palm Beach counties. If you have questions about criminal law or related matters, Call into the show at 1-888-565-1470. Join us every Monday at 5 p.m. for Muska Law Radio, a program dedicated to all criminal defense matters. Joining us live now in our studio, here is attorney Harley Brook.
Okay, we're back. So just talked about whether or not to testify and the reasons to testify or not. So if the client at the end of the day has had 2 beers over 5 hours with a big steak dinner and is a big guy, for example, 6'4", 250, whatever, and that's the testimony that he would give. He's got no prior felonies, no prior crimes of dishonesty, and speaks well. Might be a good guy to put on the stand. Might be a good witness to have, particularly if it's a professional type person who again speaks well. So those are all things that need to be discussed. The pros and cons of testifying. And like I said, in many cases, the defense might not have a case in chief to put on at all. We just attack the state's case as being insufficient, and that's the end of it. If you have any questions, again, please give us a call. It's a toll-free number, 1-888-565-1470. That's 1-888-565-1470. All right. So we're at that point. Let's assume that we've either the defense has either finished their case in chief with their witnesses or didn't put one on and announces that they rest. Usually the defense, both at the break, and by the break I mean between the state's case in chief and their own case in chief, usually the defense attorney will move for a judgment of acquittal based on insufficient evidence to prove beyond a reasonable doubt. The judge will decide if there's enough evidence to go to a jury, and if not, then the judge may go ahead and grant the motion for a judgment of acquittal and acquit the client right there. Those are pretty rare in DUIs, but there's some basic things that prosecutors don't miss, or at least they shouldn't, such as venue, meaning where it happened. They have to discuss what county it happened in. Obviously the defendant has to be ID'd. It doesn't matter that he's sitting next to me. He has to be pointed out as the defendant, and properly identified. So, those types of things, that would be really bad if a prosecutor missed one of those. But absent those types of huge mistakes, judgments of acquittal are pretty, few and far between. We would renew that at the end of our case in chief, and assuming the judge denies it, as they usually will, then it's off to closing arguments. Closing arguments to me are the most fun part of trial, because that's where you get to take the facts and interweave them with your argument. You get to give examples. You get to really be creative and make the argument. And the argument is the most fun part. Sure, you can say that you take a look at a glass, 4-ounce glass, and it has 2 inches of milk in it. And the prosecutor might say, well, that glass was half full, and of course, I'm going to say that glass was nearly empty, not half empty, nearly empty. So arguments are fun, and that's the time to make those arguments are during closing arguments. They still have to be proper. They're still subject to objections, obviously, and on both sides. And it's my job, obviously, as an experienced and seasoned defense attorney, to make sure that the state does not make any improper arguments, nor does the state disclose anything during their closing arguments that were not in evidence. Let's say that I got during my motion in limine, let's say that I got a particular piece of evidence excluded. Let's say the prosecutor forgot about that and forgot that it wasn't even brought out during their case in chief or during the trial. And they make reference to it in their closing arguments. That's not only objectionable, but grounds for a mistrial. Same thing as if they had asked that question during the trial. And I'll give an example. Let's say that we're going to trial on this DUI, and in addition to the DUI, my client had carrying a concealed firearm. If we had those charges severed, which we should, and let's say the prosecutor during their case in chief asked the detective, what else was in the car? And the detective says, well, we also found a handgun. Objection. I would ask to approach the bench immediately and ask for a mistrial. If that evidence was excluded through a motion in limine and it's brought up, whether it's in the case in chief or again, let's say the prosecutor forgets that it was never even brought up, but had been so busy preparing that canned closing argument that they forgot to leave that part of it out, that's not only objectionable but could lead to a mistrial. Well, what's a mistrial? A mistrial basically is where the judge ends the trial right there. Now, a lot of people think, oh, mistrial, that means they go free. No, that doesn't mean they go free. It means that particular trial is null and void, and we have to start over another day. Now, sometimes the state, may feel inclined to not try that case again and may offer a good plea deal to avoid a second trial. Or sometimes they'll just lick their wounds and give it a second go. Mistrials can be had from both sides, by the way, not only from the state but from the defense as well. For example, let's say that a key witness for the state testifies. Perhaps it's an officer who has a prior disciplinary issue. That may or may not be admissible. For example, let's say if the state had filed their motion in limine trying to keep that out and the judge agreed to, I'm hoping he wouldn't. That should be fertile ground for cross-examination, but for the sake of argument, let's say the judge kept it out during the motion in limine, or granted the state's motion in limine, and say I cross-examined that particular officer about that disciplinary history. Then that would be potentially grounds for a mistrial on behalf of the state, and they would have to decide if they would want to continue or whether they would want a mistrial and start over. And if it's the witness is important enough, they would probably ask for a mistrial. So that is basically the process of a trial in a nutshell. But really, the trial starts the minute that you call your attorney, the minute you retain your attorney. Even if it doesn't end up in a trial, or if you know for a fact that you're not guilty and that being prosecuted is a complete miscarriage of justice, the process of trial preparation begins the moment you speak with your attorney. And it begins by asking your attorney about their experience in handling these types of cases. It means asking your attorney about his trial experience or his or her trial experience. And once the attorney is engaged, it's discovery. Looking through every bit of it. Is there something missing? Is there something to be had? Is there a video? Is there no video? Why not? All these questions need answers, and in order to have a successful defense of a case, whether it be by plea negotiations or ultimately through a jury trial, those are things that need to be explored by competent and experienced defense counsel. At the end of the day, the client is the one who decides whether or not to go to trial. There's risks and rewards, obviously, and again, that's something that is the client's decision. The attorney can give his or her opinion to the client, based on their experience, based on the facts of the case, based on the video, if there is one, and there usually is, and all that. But at the end of the day, it's entirely the client's decision as to whether or not to proceed with that trial. The strategy for the trial, whether to object to something or not, what types of motions in limine to file, motions to suppress, things, the strategy involved of it, yes, that is within the realm of the attorney. Not that they wouldn't discuss with their client what they would be doing, but the decision to go to trial is ultimately up to the client. And again, no defense attorney, no matter how experienced or inexperienced they are, has that crystal ball to tell you what is going to happen at the end of the day. But obviously a seasoned, experienced, and knowledgeable defense attorney can take a look at a case and say, John, this is a case that you just don't look good on the video. You blew a high number, or you refused, but you just don't look good on the video. There's several other indicators. It's probably, in front of this particular judge, not the best case to go to trial on. You may want to have me negotiate the best possible plea deal that I can, and with good working relationships with the state attorney's office, I've been able to do that many times over on cases, sometimes even very strong cases. So that's something to be considered. Another thing is the client's tolerance for stress. A trial, no matter what, no matter under what conditions, is always a stressful experience for the client. So if it's a good plea offer and the client just is in a position, perhaps doesn't have a good heart, or suffers from a great deal of anxiety or whatever, maybe a situation where they may want to accept the plea. However, it's those cases that come in that are good, perhaps in the state's eyes not good enough to offer a reckless driving or dismissal, but in our experienced eyes, because remember, a lot of DUI misdemeanor prosecutors are not all that experienced. They may be out of law school for 1 or 2 years. They may be out more. It just kind of depends on the area and how much of a turnover the state attorney's office has. But for the most part, misdemeanor DUI prosecutors don't have as much experience as hopefully your defense attorney does. So they may not recognize some of the telltale issues that may lead to an acquittal. So it's those cases where we see the legal issues, where we see the good evidence, where we see the weaknesses within the state's case. Those are the ones that get us excited, or at least they should. If your attorney can't get excited for a trial, then you got the wrong attorney. I'll tell you right now. Because when I go to trial, I'm very excited. And so should your attorney be. Because I'm there to win. I'm there to get the client the result that he's looking for, that I'm looking for, and that's an acquittal. So it's important that your client, or excuse me, that your attorney have the passion, the knowledge, and the experience to get you that kind of outcome. So that, in a nutshell, is our show for today. Next week, we're going to talk a little bit more about other types of cases, actually. We've been discussing DUIs now for about 3 or 4 weeks or so. And, of course, we're a full criminal defense law firm handling cases from, obviously, DUIs. We do more of those than probably any other type of case individually. But we also handle quite a few number of sex cases and drug cases and cases of domestic violence and other types of violent type cases. So we'll get into a little bit more of those different types of cases next week. So I hope you tune in, and we're going to have another good week, and going to enjoy discussing all this with you. God bless, and have a great week.
You have been listening to Muska Law Radio. Muska Law is a criminal defense firm with offices throughout Florida, including Broward and Palm Beach counties. Join us every Monday at 5 p.m. right here on AM 1470 WNN, or log on to muskalaw.com. That's MUSCALAW.com, and watch the program stream live. Listen in again next week, and thank you for joining us. The opinions expressed